I'm not a lawyer, but there's a new lawsuit in the Diddy universe, but this time it was filed against Christan Combs, Diddy's son, Diddy, and some John and Jane Does. Now, before I tell you what is alleged in this lawsuit, I first want to tell you about the attorney that filed this lawsuit, because it's getting messy with the attorneys. So this is Tyrone Blackburn. He is the attorney representing the plaintiff in this new lawsuit, but he also represents Rodney Jones. And if you don't remember, Rodney Jones is the plaintiff in the lawsuit that was filed back in February and was recently amended. That lawsuit has a number of defendants, including Diddy, Justin Combs, Cuba Gooding Jr., as well as Motown Records, Universal Music Group, and the CEO of Universal Music Group, whose name is Lucien Charles Grange. Okay, now follow me, because this might be a ride. So for the last couple months, since that Rodney Jones lawsuit was initially filed, there has been a lot of back and forth between Tyrone Blackburn and the attorney that represents Lucien Grange, Motown Records, and UMG. That attorney's name is David, and again, he represents all three of them, Motown Records, UMG, and Lucien Grange. So after some back and forth, Donald sent a scathing and shady letter addressed to Tyrone, basically saying that the lawsuit he filed on behalf of Rodney Jones is completely and demonstrably fabricated and untrue. And just to be clear, David speaking specifically about the claims against his clients. He is not talking about the claims against Diddy or anybody else in that lawsuit. Okay, so here's the letter that Donald sent, and I'm going to read just a couple pieces from it. Quote, "This just scratches the surface of your complete failure to conduct anything remotely resembling a reasonable inquiry into the facts before filing a pleading filled with offensively false accusations." Donald goes on to say that the RICO allegations are wholly deficient, substituting non-specific group allegations and conclusions for a single factual allegation connecting our clients to your imagined over 20-year alleged criminal enterprise in which our clients have never had any involvement whatsoever. Another part of the letter says, quote, "It is not merely that the entirety of the complaint as it pertains to our clients is scandalously false, accusing our clients of engaging in criminal activity when the accusations have not the slightest factual basis. It is that you indisputably did not conduct the slightest inquiry into the facts, instead finding it expedient to spew this unadulterated mass of baseless accusations as to which you were utterly indifferent to the truth." Damn. In a publicly filed complaint. The sheer recklessness of your complaint goes beyond any complaint I have seen in nearly 50 years of litigating in the federal and state courts in New York. That superlative is no compliment. I intend to examine whether, in addition to the other offenses you have committed, you are also guilty of ethical violations in the filing of this complaint, which I believe you most certainly are. Okay, last quote. "We understand as well that you personally provided advance copies of this complaint to the press. In doing so under New York law and potentially California law, you have forfeited whatever benefits of the litigation privilege that might arguably attend to the filing of a knowingly false pleading and have subjected yourself and your client to well-founded defamation claims. Depending on how swiftly you withdraw or amend this complaint to delete all reference to our clients, we will evaluate when and where they will proceed against you and your client." It's obviously pissed. Okay, you ready for the short version? David's saying that Tyrone filed this lawsuit knowing that it was BS against his clients, and that is a Rule 11 violation. So let's talk about Rule 11. Rule 11 is a federal rule that when you file a lawsuit, you as the attorney are acknowledging and verifying that you have done a reasonable amount of investigating the claims or looking into them before filing. It also says that by filing a lawsuit, attorneys are agreeing that the suit is not for any improper use, such as to harass or increase costs. And the attorneys further certify to the court that the claims are warranted by law and that the allegations are supported by evidence. So again, David is saying Tyrone included his clients knowing that the allegations against them specifically are false and unsupported by evidence, and he did it for the purpose of media attention. Now here's where things get sticky. Tyrone Blackburn has another case in the Southern District of New York, and the judge in that case just made an order saying the same thing about Tyrone. In one part of the order, the judge writes, "Tyrone Blackburn has, as he admits, failed to meet his Rule 11 obligations in this case. It appears that this is a part of a pattern. The court declines to impose sanctions pursuant to Rule 11 or its inherent power, but will refer him to this court's grievance committee. there is a basis to believe that Blackburn is filing cases in this district without diligently investigating the existence of either jurisdiction or venue as required by Rule 11. Then the judge kind of goes over Rule 11 that by filing any motions, lawsuits, or anything to the court, an attorney is certifying that to the best of his or her knowledge, information, and belief, they have done a reasonable amount of investigating the suit or the motion for any improper use. The judge continues on saying that at the March 5th conference for this particular case, defense counsel reported that Tyrone Blackburn had told her he filed this case in federal court because doing so would make the press more likely to pick it up. A reasonable inference from Blackburn's pattern of behavior is that he improperly files cases in federal court to garner media attention, embarrass defendants with salacious allegations, and pressure defendants to settle quickly. Indeed, his submissions to this court have been rife with disturbing allegations against the defendants and defense counsel. So while the judge did not sanction Blackburn, he was referred to the Grievance Committee of the district for whatever action they deem appropriate. So all of this is happening in this other case that Tyrone Blackburn has. But last week, David, the attorney representing Motown, UMG, and Lucian Grange, found out about that order. And so he wrote a letter to the judge that's overseeing the Diddy case. That's basically, you see what Tyrone is getting in trouble for doing in this case? That's basically what he's doing here and what I've been saying that he's doing here. In this new letter, David ends his saying, "It's painfully obvious that Mr. Blackburn believes he is free to flagrantly violate Rule 11 in furtherance of trying to garner press attention for himself without regard for the truth and without regard for the human consequences of his conduct. We have served Mr. Blackburn with a Rule 11 motion, but this court has the inherent power to address Mr. Blackburn's conduct, and we believe that Judge Coates' opinion from the other case and the facts set forth therein are relevant for this court's consideration." Ciao. So just to be clear, all of this has no bearing on the federal criminal investigation that's happening, but it definitely may have an impact on this Rodney Jones lawsuit and potentially this new lawsuit that's been filed against Christan Combs, Diddy, and the Jane and John Does. All right. So now y'all want me to tell you about the new lawsuit against Christan Combs? Come back. I'll make another video.